To turn to our program for this evening, we're very fortunate to have with us now representative of and a person who is very active in being a neutral on JAMS. We have Patricia Thompson, who's an arbitrator and mediator for JAMS, and we have Joanne St. Louis, Director of Diversity Outreach at JAMS. She's former chair of the Diversity Committee in the DR section of the ABA, and she's co-chair of the podcast DR section. So with no further ado, Patricia or Joanne, whoever wants to start, please take it away.
Perfect. Thank you so much for having us today. We're excited to be here, and I could not talk about being a neutral at JAMS without bringing one of my neutrals to give you firsthand experience of what her journey looked like. But before we start, I'm just going to talk a little bit about what is JAMS, the rules, things like that to kind of set the tone. So JAMS is one of the world's largest alternative dispute resolution providers. We have 27 resolution centers worldwide. These centers are located in various cities across the US, as well as in Toronto and in London. JAMS handles different types of cases. Underneath more the umbrella of civil litigations, which include but not limited to commercial, employment, construction, healthcare, life sciences, mass tort, IP, PI, etc. I will say that some nuances that do set us apart from some other providers is that we do handle a lot of family law cases, MDLs, multi-dispute litigations, probate, trusts, those types of cases as well, which sometimes are a little bit outside of the umbrella for other providers. I'm going to turn it over now to my colleague, Patricia, which is going to talk a little bit about the different types of rule sets that we have at JAMS. Patricia, take it away.
Well, JAMS early on worked with the construction industry. We have some very experienced construction neutrals, and they're tied into all the various drafters of forms and people who are considered the leaders in construction litigation. And they said, what are one of the main problems in construction litigation? That is, people don't have time to stop a project mid-project to have a lawsuit. So they drafted these expedited, a couple month long processes, all set up in rules. You can just say, those are the rules we're going to follow. And it provides for the rapid resolution of fairly narrow but important construction disputes so that projects can continue. So that's an example of especially tailored rules that JAMS has set up. They have rules for class action procedures. They care a lot about consumer disputes. There are quite a few of consumer forms that provide for JAMS to be involved in dispute resolution, and JAMS goes out of its way to not only have special consumer rules that protect the consumer, regardless of what the contract says, because it won't be involved unless the consumer is protected. But they also take a lot of time to train their neutrals on the special things they need to think about with consumer disputes, which I may talk about later. They have international rules. It is maybe one of those secrets that JAMS does international work, but it does. It has special employment arbitration rules. We have, and then all of the various commercial arbitration rules. But they update them periodically. They're very thoughtfully drafted. Let me just add one more thing to what Joanne said, which is that the type of work we do, there's a really special niche that I love. And that is that the Olympics, the Special Olympics and the regular Olympics, after the debacle concerning the doctor who was mistreating young girls, young athletes, the Olympic Committee put together a special arbitration process for resolving claims by athletes that they are undergoing some sort of abuse. It doesn't have to be sexual, it can be other, but they are specially tailored and they are lightning fast so that neither the coaches' lives are unduly interrupted to resolve, nor are the athletes. It is very confidential. It's not about money. It's about whether those coaches can continue. And the processes are quite fair. And JAMS is the group that is designated. So whenever I get a call from the woman at JAMS who runs this program for the Olympics, that they need something right now. I mean, you have the initial hearing in 7 days. You set up a hearing conference. It's just great. And you feel like you're part of changing people's lives for the better. That's a very unusual thing that JAMS does.
As well as I know that you had, when we had our prep call, we talked about also our appellate rules
Oh,
that we're really
yes.
proud of as well. And just to put out there that, we do have a lot of retired judges that are on our panel, and a lot of them are appellate judges. So it's really nice to be able to have someone that is, that has that keen eye, that knows what to look for, especially if you have to have any type, if you have to use the appellate rules at any point in time. Uh,
Yeah. It's a
so
great thing because it puts to lie the myth that there's no right of appeal in arbitration, because there are very effective rules in place at JAMS to allow for private appeals. Go ahead, Joanne. I'm sorry.
No worries. So now we're going to just kind of go into a little bit what it looks like for a traditional case to come through at JAMS. One big thing that we really strive for is the white glove service. So when you have a case that gets filed through JAMS, what does differentiate us? Well, I guess some of this is the same, but then I'll go into the fees, which does differentiate us. When you have a case that comes in, it goes into our arbitration intake team that really has a keen eye, that is looking at all the rules that need to be addressed to that case. We make sure that the demand is complete, that the other side has been served. We request that there's proof of service. We make sure that the contract is attached, so that way we know what rules are being adhered to, if there's special nuances within the contract, or what what kind of neutral that you need for the case. All of those things are attached, as well as a statement of claim. We ask for that statement of claim so that we also know what kind of specialties that you're looking for. And then, as well as the initial filing fee, all that needs to be submitted at the initial. We do have on our website, along with the rules, alongside of our filing fees. Traditionally, our filing fees are about $2,000 for a one-party case, $3,500 for a multi-party case. If you have a counterclaim, that's $2,000. The only type of cases outside of the consumer cases, as well as the employment minimum standards type of cases, you'll have to look on the website. You'll see that the way that the fees are a little different, and that kind of goes along when you're looking at all different providers that handle employment minimum standard types of cases. It falls in line with that. Something else that differentiates us, we do add what we call a case management fee. Those are assessed with all professional fees, and that doesn't get assessed till after about 10%, about 10 hours of the neutral work that gets put in. So when you look at your overall fees that you pay, the things that get included with that is all the work that the case manager has to do. If it's a virtual hearing, you have a vader that is on that case, that's assisting throughout the life of the case, moving you around, making sure that you have the proper rooms that you need. If you need hearing rooms for your particular case, there's no additional fee that you get billed. All of that is within your filing fee. Food when you get to that hearing, they're really great. They'll do breakfast and lunch, snacks in certain conferences. I get there when I'm in the offices. I'm like, oh, they bake fresh cookies for you in the afternoon to give you the extra pick me up. Um, all of those things that you get within the overall case management fee, all of that comes with those charges. So then once you get that case filed with us, we do give you a list of 7, unless it's the streamlined cases, it's a list of 5. We ask that you strike 2 and then rank the rest. At times, parties may ask for a new list that maybe they're not liking the list that they've gotten. If both parties agree, we'll provide a new list. Otherwise, if you request a new list, we do ask for you to state why you'd like a new list, and whether is it a contract issue? Is there, someone in there that you're like, hey, there's probably some type of disclosure that they shouldn't be on the list. And then from there, it goes to our National Arbitration Committee, and then they'll review what the request is, and they'll make the ruling whether or not there's a new list. But again, it's a parties process that is really big for JAMS. So if both parties agree they want a new list, we'll provide a new list. And if, let's just say, the first round we don't get a mutual agreeable arbitrator, we do circulate another list. We try our best to make sure we do not administratively appoint. We want to make sure that parties are agreeing to who the neutral is that they get for the cases. So that's a little bit of what the commencement of the case, the white glove service of making sure that you have someone alongside you assisting with the process throughout the life of the case. Also to keep in mind just the technology also that comes in with JAMS. If you're in an office, whether you need a prep session for tech prior to, let's just say you have like your client, you're like, hey, I'd like to do a dry run through with the Vader to make sure that they're ready for the actual mediation or arbitration. All of those things are included, and that is what makes us the importance of that white glove service, that you get all the service that you need prior to that hearing and during the hearing, and even afterwards as well. Um, when it comes to mediation, we do not have a filing fee when it comes to mediation. That is one thing that's a little different for us. With a mediation that comes in, we only charge a non-refundable case management fee, and that really depends on the hourly or daily rate of the neutral. So that's where it's a little different. With mediation, parties usually come to us that they're either looking for a list, we can provide them with a list, or sometimes they come to us, they already know who they'd like. And if they're not sure, we give them suggestions the same way we do in an arbitration for them to look at. So that's a little bit about the overall commencement process. Just want to talk a little bit about our diversity initiatives. I'd be remiss to given my role if I didn't talk about that, which is really important to us. We are the first provider to have a full-time diversity professional working at our institution. And with that, I can say that we are proud to say that we are about 45% diverse on our panel. That's about 35% women, 16% race diversity, 4% LGBTQ. We have about 6% veteran status as well as disability status. Like we taking into account the whole encompassing of diversity. All of that is important to us here at JAMS. And we do keep track also of our selection because we want to make sure that the selection looks like the neutrals that we're bringing on the panel, and it falls right in line along with our what the selection for our neutrals look like, alongside with what the neutral panel makeup is. I will say that women's selection is slightly higher at about 40 to 41%, which is really great to see, even though we have a 35% women rate on our panel. Also, top initiatives that we pull out, we do have what we call an inclusion clause that we like to push out there. The inclusion clause, what I'd love to say is that it does not list any provider. The inclusion clause is something that parties can put out there that says that you will consider utilizing diverse neutrals. It does not say that you need to. It just makes it as like when you look at the contract, when you're saying, hey, what kind of neutral, what kind of subject matter expertise that I'm looking for a case, it just makes it a qualifying proponent saying that you're keeping it top of mind of looking at a diverse list. Something else that I love to tout out there is our neutral utilization report. This is great for, and you can give for overall firms or overall companies for them to see what their utilization is. And this actually helps too when they have a little bit of that monotony of utilizing the same individuals, so to be able to expand their reach and look at all available talent that's out there, especially because we're always peppering in new neutrals at all different providers. So it's a great way for you to kind of see who your selection is across the country, especially if you're a bigger firm or if you're a smaller company. Um, and then also we have our JAMS fellowship program. The fellowship program is a pipeline program that we look for up and coming neutrals that are looking to build their practice. With that diversity fellowship, you don't need to be diverse. We do have a writing statement that says that, hey, how have you advanced diversity within the profession, or any type of barriers that you have overcome? And what we do is with this fellowship, it is a year-long program. We do training with you. We give you all the same resources our JAMS neutrals do. We provide you with a mentor and a senior advisor. You get to shadow the JAMS neutrals. We work with you on building a marketing plan on how to market yourself, help you create writing opportunities to really bolster up your practice. That way, when you leave us, at some point, maybe you'll consider us. If not, it makes you ready for any other panel that's out there. And that's one of our pipeline opportunities. This year is our third cohort, and excited to say out of the 3 cohorts that we've had, at least 4 I want to say 4 of the fellows have joined us. So I can say that it is successful. And some of them have joined other panels, which just means that that's an additional success because they're out there thriving in this space. So now I'm going to stop talking and I'm going to turn it over to Patricia. As we talked about pipeline opportunities, would love for her to talk a little bit about how her recruitment process and what it's like for her being a neutral on the panel.
So let me go into that transition by first starting with the value of having so many diverse neutrals to work with at JAMS. Are you all aware of the studies? Forbes has done a study, the Harvard Business School has done a study. I imagine there are more, but I stopped when I read about those two as they were impressive enough that decision-making among groups, first of all, decision-making is better in a group than one. And among groups, decision-making is better, especially business decisions are better, more accurate, they're more predictive, the more diverse the group is that is making the decision. So here are some, I'll just give a few statistics, but I thought they were so cool. They said that if you have a team, they will outperform individuals 60% of the time. If you have gender diverse teams, then they will be right 73% of the time. But when you add different ages, different genders, different geographical locations, in other words, people who don't come from the same pattern of thinking, then you increase the quality of the decision making to 87%. So we just went from 66%, which is kind of a little bit better than tossing dice, to 87%. And there's similar results in the Harvard Business School study. So you want to be part of a group that says, we want to bring the best decision-making to bear to the clients who come to us. I believe in that firmly. So JAMS, in order to do that, when they decide they would like to bring you on, and they do that after interviewing you, after interviewing other JAMS existing clients about, have they heard of you? What kind of business would you bring in? They want people that it looks like they would be successful. And then JAMS does what it can to help make you successful in a number of ways. First of all, JAMS training is incredible. Not only do you go through several days of training to learn ADR, they train you in how to develop business. They assign you someone who is a professional marketer on staff to help you develop your business, because it's really hard to do. And they are constantly, every month, I get a list of the training programs that are available, new ones, online, live, attend, ask questions. And it covers everything you can think of. Recently, I got a call from someone I know in Florida who's an arbitrator, and she said, how do I go about assisting the parties and issuing a third-party subpoena? I was able to answer that because JAMS has 3 programs on how you do that. That's just online. They recorded them, and they have programs about everything. So I'm really proud of that. I'm not very smart about it, but to the extent I know what I know, it's because JAMS has taught me. The marketing group helps you get articles published, helps you find speaking opportunities, but it is truly up to you all as well to make your business flourish. They will help. They will assist in every way possible. They'll come up with ideas and opportunities, but you have to put in your work. So honestly, when I first started, I was told by JAMS, look, you're going to send out notices going, yay, I'm a JAMS neutral. And nothing's going to happen. Nothing's going to happen. All the people you know you because you used to be something else. And I was an attorney. They don't know you as a mediator or an arbitrator. And when they're thinking of mediators and arbitrators, they don't think of you. They think of the ones they just used. So you have to begin to get in their minds. They need to become aware of you. And that requires you to speak and to write and to train and to speak and to write and to train. But it works. It really works. I mean, I'm just delighted by my practice. It's been successful. JAMS has given me self-confidence. If I'm in the middle of a proceeding and suddenly one of the parties declares bankruptcy, and I was never a bankruptcy attorney, this happened to me. And everybody said, oh, well, this is what's got to happen. Only they weren't in agreement about, oh, well, this is what's going to happen. I contacted somebody at JAMS and said, can you think of someone in JAMS who can help me? And they said, oh, yes, Judge so-and-so up in Boston was a bankruptcy judge. I'm sure she'll be delighted to stop everything she's doing and talk to you for 45 minutes, which is exactly what she did. So that I could then ask the questions I needed to ask of the parties, direct them to give me the research I needed to make my decision. But I wouldn't have known to ask for that without the assistance of that woman. And this happens over and over again. Sometimes I'm the one getting the calls. Sometimes they're the ones giving the calls, but it's really very supportive. So I guess I'll stop at that. Joanne, is there anything that you wanted me to cover that I didn't? Because it's kind of hard to remember when you're talking.
No, it is all good. I'll talk a little bit more about, when you're looking at who they're looking to bring on, they're looking at, do you have, any type of ADR experience? If not
Yes,
ADR experience, they're really looking at your subject matter expertise,
yes,
and looking at how many years have you been practicing. Another big thing is that civility. That is so important when they're asking those questions to the clients out there. So civility is so important of how, you play with both sides of the aisle. Also, let's just say outside things that you do. Are you part of bar associations, other
yes,
organizations? So all of those things come into account. And I will say it's never one of those like, oh, you send your resume, and then all of a sudden you are on the panel.
mhm,
It's lots of conversations because you want to make sure that this is the right space for you, and they want to also make sure that this is the right place for you. One other nuance to put out there that does differentiate us from some other providers is that we do ask that folks that are, that are mediators and arbitrators on our panel, that they are not actively practicing law. So you are just an ADR professional. That does not mean that it precludes you if you are a professor or if you have maybe some type of other business that is outside of the legal profession. You can still do all of that, but the active practice of law, we do ask that you are not in a firm. And what happens with that is that it just kind of mitigates any type of disclosure issues that you may have, especially if you're in big firms and other cases come in that may cause other issues for other neutrals, or just disclosure issues in general. So that is something that is a little different. I will say that that doesn't mean that, say, if you are listed on a FINRA case or you're listed on a CPR case, that you can't be at JAMS. That is not the case at all. Also, to put out there that, even though you're at JAMS, if both parties agree for you to be on a case for another institution, you can do that as well, and we will, the case manager will assist. Even if they administer it, they can still use JAMS neutrals, and or if both parties agree, JAMS can also administer cases that are using another set of rules, as well when you're utilizing a JAMS neutral. So really, anything is possible as long as party agreement. So the big thing we always say here at JAMS, it is the party's process. So we will always try to make sure that we can adhere, as long as it's within our way that we can do it, it doesn't cause any type of issues, that we will try to administer cases for individuals. Um, and then just a little bit that is a little different as well. Case managers at JAMS, so neutrals, they each get their own case manager. Like, it's your
mhm,
own assigned. You're never going to say, hey, you got this case that came in Boston. All of a sudden, it's a Boston case manager handling it, even though it's with Patricia that's in Miami. It's always going to be Patricia's case manager handling that case. And the reason why that's really great, it gives you that white glove service of knowing that she knows Patricia's calendar. She knows what days are blocked. She knows when she's going to be on vacation, when there's an opening, whether or not she can fit in a case, especially if it's a mediation. Maybe you don't need a full day and she has something later on in her calendar. You're able to have that one-on-one, that case manager that knows that dedicated neutral. If there is something that maybe is not listed on their bio and they know that they've had, because we have reports that we provide the neutrals all the time with what kind of cases that they may have, they know what kind of cases that are on their desk. So if there's something that's nuanced that you call in and you're looking for a mediator, that case manager can properly give you who's the best neutral for that, because they have dedicated case managers that work with them on a regular basis. So that's something that's a little different, that I find to be very beneficial. That also, gives you that white glove service.
Yeah. Yeah. And they advocate for you. I mean, it really, my case manager and I feel like we're a team, and she helps me do better and she makes the clients happy. She and I both, we want to make the clients happy as far as service is concerned, but she also wants to keep me happy as far as what I need from them. So it's like having an advocate or a team member. It's really nice.
And then one other thing I'm just going to put on there, I know there's probably questions, I want to leave space for that. I know you talked about the practice development and all of that, but I think when you talked a little bit about how you can reach out to individuals, it's good for people to know that when you join JAMS, you're also assigned a mentor. And that mentor allows you to shadow, and they actually let you shadow other neutrals when you first join the panel, but you have your assigned mentor. And at times that mentor can even serve as a sponsor, which I think is great. I have seen mentors that have reached out to the colleagues that they have and said, hey, why don't you co-mediate this? And I'll actually share my fee with you. Some have done that. Or if they're busy as a mentor, they'll say, hey, you should utilize Patricia. She has along the same type of experience that I have, and her calendar may have availability. So they serve sometimes not only as a mentor, but also as a sponsor, which I think is great. You also get assigned a senior advisor. A senior advisor at times can be an individual that may have had the same career trajectory as you. Let's just say if you came from a law practice and you're transitioning to that ADR, maybe you came from a judicial practice, you're transitioning to ADR. They've had that same background, and or it may be a practice area expertise, like Patricia said, someone who has, extensive bankruptcy experience or extensive appellate experience. That way, if you have any questions, maybe along that line that you need to reach out to somebody, you have a list of individuals that have raised their hands to say, hey, I'm willing to serve as a special, a senior advisor if some type of, something comes up with this kind of practice area expertise. So that's a little something that is a little different. I don't know if other folks have it, but I think that it is truly a gem. And just to really hone in on that JAMS Institute. The JAMS Institute, as Patricia said, they have monthly programming. They are live programming. Some of the live programming is recorded. They allow you to also get CLE credits for some of those programs, especially for those that need those CLE credits to stay active. And then when you have that on the library at any point in time, you can go back and take a look at it. And they have, whether it's, extensive arbitration training, it could also be mediation training, special nuance trainings. And it's a great time for you to learn from other neutrals to see what has worked for them, what has not worked for them. And it's a great forum to be able to, to grow in your ADR practice. So I'm going to stop there. And I'm going to pass it back to you, Karen, to make sure that there's enough time for Q&A.
Thank you both. So that is such a rich presentation. I don't know where to start that. I've been somewhat familiar with JAMS because, as Patricia and I were discussing earlier, we're both very friendly with a woman in Florida who has been active on JAMS, and I've learned a lot through her. But I learned so much more today that I would never even imagine was possible. I just have a couple of questions that I'd like to open up the questions to most of the people in the group here because I'm sure that they have many. In my situation, my background is not in litigation. I was a corporate transactions securities lawyer before I became a neutral for first for FINRA and then later for AAA. But I do spend most of my time, about 50% of my time, I would say, as an expert witness. In standard of care of attorneys and legal malpractice cases. Would the expert witness work constitute practicing law that would exclude me from being on JAMS as a neutral?
I think that would have to be more of a nuanced question, so I can't give you a response there. And the reason that would be, you'd have to have those questions of, okay, well, how are they reaching you? Who are the clients that are reaching out for you to be, an expert witness? Because then we got to figure out, how are we tracking this? Because that's also creating disclosure issues, right?
Yes.
Sure.
So those are things that it's going to be a very nuanced thing, to be honest with you, and in a bigger conversation of what that looks like. How robust is that practice? Because if it is a very robust practice, it can create really big nuances where if you're getting called in by big law firms, that creates a ripple effect of disclosures for many other neutrals. So,
Right.
but we never say no, because we've had many different individuals that have joined that have had very different backgrounds.
Right.
I was asked if I would do some testimony when I first retired from my law firm and joined JAMS. People asked, "Oh, well, now that you're not in a firm, how would you like to come and do some expert testimony on various legal related issues?" And I talked to JAMS about it, and they said, "Well, if you don't ever want to do any neutral work for that law firm, I guess you
That,
could do it. And if you don't ever want to do any neutral work on an issue that's involved in that lawsuit, because the problem is you've already said what your opinions are, and every new case you get, you've got to be absolutely neutral. And if
right.
you just said what should happen in a similar kind of case, how could you possibly be neutral? Or if you testified for an attorney about that attorney's fees and that attorney's work, then you can never be neutral in a case with them. That's at least what JAMS said. And I think that made a lot of sense. And so I didn't need to do it. I don't know if that helps you, Karen.
Yeah, it does. I mean, that's it. It's important. I like to make the comparisons for the sake of our audience between JAMS and other platforms. What I've done with FINRA and AAA is that I have a very extensive database for conflicts checks. So before I take on a case as an arbitrator, either for FINRA or for AAA, if I see certainly if I see a name of a firm that's been involved in a previous matter in which I've been involved, either as a
Yeah.
neutral, as an expert, I obviously disclose it. I think in all the years that I've been a neutral, I think I've had only one case that has involved a law firm seeking to collect fees from a former client, which of course triggered the response by the former client suing for malpractice, filing a counterclaim for malpractice. And so I disclosed to both parties before I took on that neutral position in that arbitration in that case that I do expert witness work on standard of care of attorneys in legal malpractice cases, and they didn't object, but it was a definitive, crisp disclosure before before I was willing to take on that case. I just want everyone to be aware of the different ways of approaching it, but this is how JAMS deals with it, so we should be aware of
Yeah.
that. And the other question that I had is for the purposes of the Harvard Business School study and the Forbes study and other studies in determining whether empanelment of a certain nature of neutrals on a particular case results in a decision being more effective. How is more effective determined? How do you know when the decision is a good decision or not a good decision for the purposes of deciding that it's a better decision if the panel is diverse?
What the Harvard Business School and the Forbes, that was in a business situation. So in a business decision, does it turn out that that decision was supported by subsequent events? Does it turn out that that decision was good for the business? So they had numerical or financial ways to judge that. All I can say is if that's true in that circumstance, it seems to me that it is directly translatable to deciding in difficult, complex situations what the right decision is to make in an arbitration. But of course, in an arbitration, I would say one way you would know that better decisions are being made is one, the award is preserved. I mean, an award that's set aside because of an error, you already know there's something wrong with that award. But another thing is that I have found that having people say, well, now wait a minute, I'm not sure I agree about such and such. That first question means the whole panel goes back and looks at the record. And then having looked at the record, they decide, oh, it turns out, in fact, that wasn't exactly how I remembered it. The testimony really was different and different enough for a different result. Had there not been that question, that wouldn't have happened. And I think it makes a difference to have people who come from different ways of looking at things, who don't need to get along with their old buddy that they always serve with. I think you're going to have more of those discussions if there isn't a reason to avoid conflict.
And something, if I can go back to your last question real quick, something that you said really perked up something with me when you talk about disclosures. With you having all of your ADR work coming in through JAMS, I will say what does differentiate us from different providers is that we keep track of that. So when you
Yes,
get a case and we're sending, to that appointment to that neutral, we're providing you with all different type of disclosures that maybe you didn't think about,
I
and then
forgot about.
and then you
Yep.
have to maybe just double check to say, hey, is there anything else outside of this robust list that we've kept track of all the cases that have come in with these particular parties? Is there any type of other speaking opportunities? Because at times we even keep track of speaking opportunities that you have because we place them on our website. So it's another way of having another disclosure bank, a robust disclosure bank for the neutral. And it gives them that second double check to say, hey, is there anything else outside of this that may cause an additional disclosure? So sorry to go back to that question. That just
No, good. Thank you.
percolated something for me of something that is a little nuanced, that's a little different.
No, that's very helpful. I'd like to open up the floor now for everyone else
Yeah, I
to
have a
pose
question,
questions.
Karen. In listening to you, it sounded like what you were focusing on were taking people who were at the beginning of their ADR career and then bringing them along and nurturing them and training them, et cetera. How do you deal with people who aren't at the beginning of their ADR career and may be interested in joining your panel?
So I want to say the fellowship is for the beginning of your career. So that is more of a pipeline, give you the mentorship, all of that. If you're looking at joining the JAMS panel, we're looking at those that have established ADR
Right.
careers or at least have been practicing in ADR as an advocate and or maybe you are on the bench and then now you're transitioning. So I will say those that have joined our panel, they are more seasoned. They've had that 15, 20 years of practice, whether it's in law or on the bench, and now are transitioning. So I just want to make sure that I've articulated that properly versus the pipeline versus joining the actual as a full-time JAMS neutral.
Okay, so looking at that, again, the examples that you gave were people who had careers outside of ADR. Okay, like a judge doesn't have an ADR career. So do you accept people on your panel who have ADR
Yes.
careers before
Oh,
they get
yes.
to?
Absolutely.
Absolutely.
Okay, so,
Absolutely.
and how do you evaluate that? Because it sounds to me, and again, I'm just based on what you're saying,
Mhm.
excuse me, that you're very protective of your panel and what they do. So you mentioned CPR, we've heard AAA, there's a bunch of other panels. You say they should not be practicing law, but what about being on the other panels? And just like Karen was saying, frankly, I've had an ADR career since the late 1980s, so you can figure the math out, and I keep my list, just like Karen does, and other organizations also keep lists. How would that affect you in terms of bringing somebody in that has that type of experience? Or would you prefer not to and, start with
Oh
training
no,
people the way you want it?
No. We want you to come and bring your experience. And then we have our training, just like when you see other panels that have their initial training in the onset so that you know how JAMS does things, because that's important to know. Because the way you may do it on a different panel, it's important for you to understand the rules, understand the guidelines, the different procedures within the organization. So that's why we do the training at the onset. But we are looking, so say, for example, if you have your book of business, we want to see, okay, do you have an established book of business? We're going to ask you for some names names from your book of business so that we can give them a call and know, tell me what you're saying about Linda. Tell me a little bit about her practice. Then we're also going to reach out to our clients saying, hey, have you heard of Linda Spiegel? Have you worked with her before? Would you use her, if she came to JAMS? We do a lot of that vetting as well. We're also, looking at, hey, do you have speaking opportunities? How visible are you in that space? I will say when it comes to other panels may not allow you to stay with JAMS and be on that panel. But those are conversations that you'd have to have with those particular institutions.
But your panel, if someone's on your panel, they can be on other institution panels.
They can be listed, or they can, let's just say if it's a AAA case, you can be a JAMS neutral, and two parties from a AAA administered case say, I want to use JAMS neutral. That's not a problem. You can be placed on that. But I don't know if the other institutions will, they won't list you.
No, that's interesting. I didn't know that.
No.
I had heard from Finn. Go ahead.
Yeah, I've seen people that have CPR listed, have AAA listed. I mean, there's a whole bunch of, on their signatures, on their email. They belong to all these different panels.
Right.
I don't know that I've seen
Not JAMS.
JAMS and other panels listed. So that I guess, so what you are saying is that if someone joins your panel, you really want them to be exclusive to your panel.
No,
we do want them to, go ahead.
No, that implies that they can't do other organizations or ad hoc arbitrations. The problem is that the other organizations won't allow you to be a AAA panelist if you come to JAMS. You see, so JAMS.
Okay, all right, I understand what you're saying.
Yes, so you can do that work, but you'd have to be appointed by the parties as an individual neutral, because they want you, even though it's being administered by AAA. But if you're a AAA panelist and you want to come to JAMS, AAA will say, thank you very much. It's been nice knowing you.
Yep.
Okay, all right, that's interesting.
Never knew that.
Conversation.
Isn't that right, Joanne? I think that's true.
That is true. And actually, they've started putting some things in their rules saying that you can only use their panelists. Like they are trying to.
We don't say that.
And we don't say that either.
No.
Okay, thank you.
No, if I'm asked by a party to serve on a case and someone else not in JAMS is asked to be the other wing, and between the two of us, we either appoint a JAMS chair or a non-JAMS chair, then depending upon whether it's JAMS rules or AAA rules, if it's JAMS rules, then JAMS is going to administer that, even though there's just one JAMS person on the panel. See, so it's not that JAMS is trying to exclude other people. It's just that they administer their cases. JAMS cases.
And they will not list outside of their panel. Right. And they won't allow you to be on their panel if you're on our panel.
That's AAA won't allow.
Yes, that's AAA.
Right.
Okay, thank you.
Well, that's an exciting piece of information that I never heard from AAA. Okay.
Well,
glad I showed up today.
Well,
I'm sorry, go ahead.
Leadership and membership of, we're independent contractors, but pretend we're members, have said this doesn't seem to be good for clients to say, oh no, we can't have a AAA person or we can't have a JAMS person. It doesn't seem to be right, but we haven't been able, for lots of complicated reasons, to figure out at the various highest levels how to be a little more accommodating.
But just know,
collaborative.
Just know that within JAMS, it is the party's process.
Yes.
You can serve on any case, administered by anybody else's rules. We don't strong arm you. It is your process. So if you're on our panel, if parties agree to you to be used on a AAA case, well, that's not a problem. If for CPR they want you on that case, it's not a problem. So it's more on the other institution if they will allow you to be listed on their roster. And when they more or less likely they will not.
They will not.
That's fascinating. Anyone else have any questions?
Yeah.
What have been your experience? Go ahead, Steve.
I have a question. It occurs to me that there could be a differentiation in areas of what kinds of cases come up. For example, I do FINRA arbitrations. Because FINRA arbitration is mandatory for members and for customers, you're not going to get necessarily those cases. The kinds of cases that would be coming in through you are not likely to be in that area. And I don't think FINRA would throw me off because I was doing other kinds of cases for you.
No.
Am I misinterpreting that?
No. I have seen some people that are on our panel that get listed on FINRA cases.
I'm on
I will
on
say that
FINRA.
just, by the way, just to correct that, because and it's an odd situation, but it does happen. I'm currently sitting on a panel, a AAA panel, a consumer AAA panel, handling a case that would be a FINRA case, but for the fact that FINRA rejected it, and I can't get into the details of why it rejected it, but
Oh.
it does occasionally happen that securities cases end up not. It may start on FINRA, but they don't end up on FINRA. So it could end up in JAMS or AAA.
Yeah, well, I can't speak to that, but I know a couple of cases that I'm currently on aren't going anywhere else.
Right, that would be the norm.
Yeah.
Right.
Yeah, but I mean, if somebody who's doing FINRA arbitrations if I came to you, and I'm not on your panel, but if I came to you and said, say, I'd be interested in doing that, I gather you're not saying I'd have to walk away from FINRA. I mean, I've been a securities lawyer for a long, long time.
No, I hear Joanne not saying that we wouldn't be required by JAMS to walk away from AAA. It's just the AAA is going to walk away from you.
Yeah, no, I meant,
Correct.
yeah, I hear you.
Let's just say if if that case does come in, it would be administered, like your case manager would be assisting with that case and all of that, if it was to come in that way. So JAMS is working with you alongside that particular case because your ADR work is being funneled through JAMS.
Okay, any other questions? Have any of you had experience, anyone else attending today had experience with JAMS, or in a case that started on JAMS and ended up somewhere else, or started somewhere else and ended up on JAMS? Any kind of interface with JAMS before today? I see a number of you are mediators. Have you had experience working with in the mediation area on JAMS?
I have.
Yeah, obviously Patricia has. Maybe we talk about the mediation side a little bit. You touched on a little bit of the difference on the process. But what has been your experience in cases, for example, in mediation, where you have mediators from a variety of different backgrounds that are either seek to be on JAMS or have their cases somehow been involvement of some mediators who are not in JAMS and some mediators who aren't in JAMS? That could happen in a complex case, like class action case, for example, that might end up in mediation for as an interim measure. You might find out you're in a room with a lot of different parties that have different aspects of the case being handled by different neutrals. Has that occurred in your experience, Patricia?
I have not co-mediated with a non-JAMS mediator or neutral. But Joanne, have you heard of that happening? I just have not heard about it. I'm sorry. I wish I could speak to it.
I've not heard about co-mediating, but say, for example, if parties have a mediation with let's just say another, say if it's with another provider and they want to use a JAMS mediator, that's not a problem. Like, you could use a JAMS mediator. As we said, it's a parties process. Whoever you select, we will administer the case. I will say what's a little different is that, if you go on our rules, you're not going to find rules for mediation. We look at it, it is a voluntary process. The only thing that's a little different when it comes to mediation, unless, you know, both parties come to us saying that you want to come to mediation, and or there may be a contract. Sometimes you'll see that there's a contract calling for mediation. Sometimes it's like, as I like to call it, a mediation step, that there's a mediation that you come to JAMS, and then after that, maybe you go to a different provider, or you may come back to JAMS if the mediation doesn't settle. So those are the two ways that I've seen mediation come in. So that's just a little different, where it's like you don't go on the website and like, oh, what are the mediation rules? What does that look like? You won't see rules and procedures around there, because it's the party's process, and the mediator will customize it based on what the party's needs are.
Karen, do I have time to add one other thing
Of
that I
course.
found to be fascinating? And that is
Sure.
there is a whole in-house counsel group at JAMS, so that when ethical issues come up, either concerning the arbitrator's authority, the selection of the arbitrator, you know how at a preliminary conference, the arbitrator says, does anybody have any objection to my serving? Well, there's actually a process in place for that immediately going to someone else to decide. I one time had an ethical thing come up that I was quite concerned about. And I was able to go and have a confidential conversation with in-house counsel at JAMS. They have several that are particularly trained in certain aspects of neutral work. And so it's not just me making a decision about what I'm going to do in a case. It is so nice to go to someone independent who's looking at a larger issue, which is what's the best thing for this process. And it takes a weight off your shoulders in a difficult decision. It's a nice thing to have.
And that's alongside with that national, that exact name for you, we call it the National Arbitration Committee, that handles some of those issues as well. So it's never through a vacuum.
Tell us a little bit more. I know we're above time, but tell us a little bit about the National Arbitration Committee, how that works.
So it's with operational folks as well as legal, that, you know, you may bring a party case forward, and they'll take a look at the bigger picture of all the different issues, and they'll make a ruling on how to move forward with that particular issue. So one example that we gave in the beginning is, let's just say the commencement, you're like, I don't like this list. It's not enough just to say you don't like a list. Provide us with the rationale as to why. And all of that comes in. They're taking a look at the list. Did it meet all the requirements? Could you have done better on this list? And then they'll make a ruling. And that can come up with a disclosure issue where it's like, hey, whether or not I'm looking at these disclosures, what came up with the parties, both have their objections. Do we remove the arbitrator? Do we keep the arbitrator? So there's different rationales or different parts of where the National Arbitration Committee will take a look at the case and make definitive rulings on how cases should proceed, especially if there's any issues that may arise.
Right. So on operational administrative matters, they're other forum to resolve the dispute.
Absolutely.
That's excellent. Well, I wish we could go on for another hour, because I'm sure there are lots of fascinating issues, but I'm sure you have other things to do. I know it's the holiday season to prepare, but I want to thank you all very much for attending. And I especially want to thank Joanne and Patricia for spending your time with us today, and really obviously having thought a lot about this presentation before you came today. So we learned quite a bit from you, and maybe we'll have you back sometime in the future to, for a continuation.
It was good to see my Florida friends, by the way.
I just want to.
Thank you. I'm a Jersey girl now, by the way, but I was in Florida. I'm sorry. Go ahead, Joanne.
Before you guys go, if you have particular questions that you want to talk a little bit more about your practice and what it could look like for you, please let me know. I can also get you connected with particular individuals that are in operations that is in your particular market, to have those discussions of what that would look like for you. Even have those discussions to see, hey, especially like Linda, is JAMS a place for you? Do you want to have those conversations? Let's have those discussions. If you, I know someone that was on the call before, Rosetta Robbins, it's like, hey, I'm trying to explore the platforms, things like that. Maybe if you're a newer arbitrator and you want to maybe look at the, the pipeline program, that you're going to be able to get more, experience, whether it's, shadowing other cases, things like that. Let's have those discussions. So please feel free to reach out. I will put my email in the chat. You all know Patricia, and Patricia's great, someone that you can go to and have those discussions. So just want to be able to put that out there, that feel free to reach out to us.
I did want to ask that, just a segue from that question, though, and I think it relates to Rosetta's question, and that is, if a person is an experienced attorney, or an experienced judge and is new to ADR, would that person qualify? So say the person is in his or her 60s or 70s. Would that person qualify for the fellowship program because that person is new to ADR?
I would say it depends on what your background is and what you're looking to do. I never say no. I had someone who was part of our practice who joined actually our fellowship last year, and they were a very seasoned attorney, new to ADR. And, you know, I wouldn't say he was probably in his second career, and he found it beneficial. So I just say, if you're interested and you want to apply, apply. And I will say, one time someone did apply, and we looked at their resume and we said, hey, you're way too experienced for this. And we started having conversations with them. It was a long conversation talk, a little over a year, but they ended up joining our panel because we said, given your background, you really look like you're panel
You're
ready.
ready.
You just need a little bit more to kind of get you there. So let's work with you to get you there so that you would be ready. So I just say apply.
That makes sense. Well, that makes a lot of sense. Happy holidays to everyone. And thank you all very much for coming.